You are listening to HOA Rejected. I wish this was exaggerated. I am watching you. That was the first thing Donna Ramirez screamed at me across my own front yard, her face already twisted with rage before I even turned around. She waved a clipboard wrapped in a clear plastic sleeve, like it made her official, jabbing it toward the freshly dug post holes along my property line. Karen screamed that I did not submit the right form, and that meant the work was illegal. Her voice cracked on the word illegal, and I could see my contractor freeze mid-swing with the post hole digger still in his hands. I live in Bend, Oregon, in a neighborhood called Whispering Pines, and the Whispering Pines HOA board runs this place like a corporate audit with teeth. Donna is the social committee chair, which apparently gives her enforcement powers she interprets as unlimited. I work as an insurance fraud investigator, so I recognize patterns fast. Right now the pattern was a middle-aged white woman in a purple windbreaker, with the hood up, gray hair pulled into a low bun, holding a small spray bottle she kept using to wet the dirt around my fence line so she could take close-up photos on her phone. She had already taken about 15 pictures by the time I walked outside. She pointed the clipboard at me again. This conversation is not a debate, it is a directive. You stop work immediately, or I file an emergency enforcement action with the board tonight. I asked her which form she was talking about, and she flipped through the pages on her clipboard without looking at me. The exterior modification request, she said. You submitted the fence installation packet, but not the EMR addendum for structures within 10 feet of the property line. I told her my fence was exactly on the property line, not within 10 feet of it, so the addendum did not apply. She laughed, a sharp bark that made my contractor take a step back. That is not how setback rules work, she said. Setback means distance from the line, and if you are on the line, you are violating the 10-foot clearance zone. I pointed out that made no sense, because the line itself was the 0 point, and she cut me off. We can tow first and explain later. That is how enforcement works. I told her no one was towing anything because I had pulled the permit from the county and followed every rule in the HOA covenant. She shook her head slowly, like I was a child who did not understand basic math. County permits do not override HOA rules, she said. You need both, and you only have one. She tapped the clipboard. I am issuing a stop work notice effective immediately. If I see your contractor here tomorrow, I will fine you $500 per day until you submit the correct paperwork and wait for board approval. My contractor looked at me, then at her, then back at me. He said he had 3 other jobs lined up this week, and he could not afford to sit around waiting for an HOA meeting. I told him to keep working, and Donna stepped between him and the post hall. She held up her phone with the spray bottle in the other hand, and said she was documenting everything. I am recording this for the violation file, she said. Every post you set without approval adds another line item to your fine total. I asked her to show me the exact rule she was citing, and she flipped to a page on her clipboard, holding it up but angled away so I could not read the text. She said it was Section 4.7 subsection C of the Architectural Guidelines, and I would receive a formal copy in the mail within 3 business days. I told her I wanted to see it now, and she said that was not how the process worked. You get the notice first, then you get the documentation, then you get the hearing date if you contest it. I asked why she was wetting the dirt with her spray bottle, and she said she was ensuring accurate photographic evidence of ground disturbance and unapproved excavation. She sprayed another patch of dirt near the second post hole and took a close-up photo with her phone held low, screen turned away. My contractor muttered something under his breath and walked back to his truck. I heard the tailgate slam. I pulled out my own phone and opened the HOA covenant PDF I had saved weeks ago when I started planning the fence. I found Section 4.7 and read it out loud. Subsection C says setback rules apply to structures that extend above 6 feet in height or occupy more than 50 square feet of ground area. My fence is exactly 6 feet tall at the posts, and the footprint of each post is less than 1 square foot. Donna did not even look at my screen. She said the board had issued a clarification memo in March that redefined setback to include any vertical structure regardless of height if it created a visual barrier. I asked her to show me that memo, and she said it was distributed at a board meeting I did not attend. I told her I had attended every meeting since I moved in 6 months ago, and she said this was a special session for compliance officers only. I could see a neighbor watching from across the street, peeking through blinds like it was a show. The contractor came back from his truck with a folded paper and handed it to me. It was the county permit with the property line survey attached. I held it up and told Donna the survey was conducted 2 weeks ago by a licensed surveyor, and it confirmed my fence was exactly on the line with no encroachment. She glanced at it for half a second and said surveys were advisory only and did not override HOA jurisdiction. I asked her what that even meant, and she said the HOA had its own property records and they superseded county documents for enforcement purposes. She pointed at the clipboard again. You have until 5 p.m. tomorrow to submit the EMR addendum and halt all work, or I proceed with the emergency hearing. I told her I would submit nothing until she provided the clarification memo she claimed existed. She smiled, a tight line with no warmth. That is your choice, she said. But when the fines start accruing, you will wish you had cooperated. She turned and walked toward her car, a silver sedan parked half on my driveway apron. I called after her and asked when the hearing would be if I contested the stop work notice. She did not turn around. She just said I would receive the date in the mail along with the documentation. Her car door slammed and she backed out fast enough that I heard gravel spray against my mailbox post. The contractor told me he could come back next week if I sorted it out, but he could not risk the HOA calling the county inspector and getting him flagged for working on a disputed site. I told him I understood and paid him for the day. After he left, I walked the fence line with my phone and took my own photos of every post hole, every string line marker, and every survey stake the surveyor had left. I wrote down every word because later I planned to read them back to her. I had a notary appointment booked for Friday afternoon to get my complaint affidavit signed, and missing it would delay my sworn statements for weeks. That was the time pressure I could not ignore. My mother was in the hospital 2 states over dealing with a liver issue, and every bogus fine the HOA slapped on me was money I could not send her way for her medical expense copays. That night I went through my records. I had the original HOA covenant, the architectural guidelines, the county permit, the survey, the contractor invoice, and my own notes from every board meeting I had attended. I could not find any mention of a clarification memo about setbacks. I checked the HOA website and found the meeting minutes archive. The March meeting minutes mentioned a discussion about fence aesthetics, but nothing about setback redefinition. I screenshotted everything and saved it to a cloud folder. Then I sent an email to the HOA management company asking for a copy of the March clarification memo Donna had referenced. I got an auto-reply saying they would respond within 2 business days. The next morning, I woke up to a printed notice taped to my front door. It was on Whispering Pines HOA letterhead, with Donna's signature at the bottom, and the date stamped in red ink. The notice said I was in violation of Section 4.7 subsection C and Section 8.2 governing unapproved construction activity. It listed a fine of $500 per day starting today, with an emergency hearing scheduled for next Wednesday at 7 p.m. in the community center. It also said that if I did not remove the fence posts by Friday, the HOA would contract a removal service and bill me for the cost, plus a 25% administrative fee. I took a photo of the notice and then peeled it off my door. The tape left a residue I had to scrape off with my thumbnail. I called the HOA management company and got a receptionist who said the compliance officer would call me back. I told her it was urgent, and she said everyone says that. I asked to speak to a supervisor, and she put me on hold. After about 10 minutes, a man named Greg picked up and introduced himself as the regional compliance manager. I explained the situation and read him the stop work notice, line by line. He listened without interrupting and then said he would need to review the file. I asked him if the HOA had issued a clarification memo in March about setback definitions, and he said he was not aware of one, but he would check. He told me to email him all my documentation, and he would get back to me by end of week. I sent Greg the email with every document attached. Then I went outside to check the fence line. The posts were still there, the concrete had set overnight, and everything looked solid. I heard a truck pull up and saw a vendor van with a magnetic sign that said Property Line Services. A man in a reflective vest got out and walked toward me with a clipboard. He said the HOA had sent him to verify fence compliance, and he needed to take measurements. I asked to see his work order, and he handed me a printed page with Donna's signature at the bottom. The work order said he was authorized to inspect the fence installation and report any discrepancies to the board. I told him I had not been notified about an inspection, and he said that was not his problem. He pulled out a tape measure and started measuring the distance from my fence post to the property line stake. I stood next to him and watched. He measured twice and then wrote something on his clipboard. I asked him what he found, and he said the fence was 0.3 feet inside my property line, which meant it was not on the line, but encroaching into my setback zone. I told him that made no sense, because the survey showed the posts were exactly on the line. He shrugged and said he was just reporting what he measured. I asked to see his measurement, and he angled the clipboard away. He said his report would be submitted to the board, and I would receive a copy in the mail. I pulled out my phone and started recording. I asked him to state his name and company for the record, and he immediately closed his clipboard and walked back to his truck. He said he was not required to be recorded, and he had completed his inspection. His truck left before I could get his license plate number. I called Greg again and got his voicemail. I left a message explaining that the HOA had sent a vendor to my property without notice, and the vendor had refused to show me his measurements. I said I believed the inspection was designed to provoke a reaction and generate a false compliance report. I asked Greg to investigate and call me back. Then I called the surveyor who had done my original property line survey. He said he could come out again and re-verify the measurements, but it would cost me another $300. I told him to come as soon as possible. He said he could fit me in tomorrow morning. That afternoon I got an email from Greg. He said he had reviewed the file and confirmed that there was no clarification memo issued in March. He said the setback rules in Section 4.7 applied only to structures over 6 feet in height or over 50 square feet in ground area, and my fence did not meet either threshold. He said he had instructed Donna to withdraw the stop work notice and cancel the fines. He apologized for the confusion and said I could proceed with the installation. I printed the email and put it in a folder with the rest of my documentation. An hour later, Donna called my cell phone. Her voice was sharp and fast. She said Greg had overstepped his authority and the board had voted to overrule his decision. I asked her when the board had voted because I had not received any meeting notice. She said it was an emergency executive session and member attendance was not required. I told her that violated the HOA bylaws, which required 72 hours notice for any vote affecting member property rights. She said executive sessions were exempt from notice requirements. I told her that was not true, and I would be filing a formal complaint with the state HOA regulatory office. She laughed. Good luck with that, she said. The state does not care about fence disputes. Then she hung up. I called Greg back and left another voicemail. I explained that Donna had called me and claimed the board had overruled his decision in an emergency session. I asked him to confirm whether that was legitimate. I did not hear back from him that day. The next morning, the surveyor showed up at 8 a.m. He brought his equipment and spent about 45 minutes remeasuring the property line and checking the fence posts. When he finished, he handed me a printed report with his signature and stamp. The report confirmed that all 4 fence posts were positioned exactly on the property line, with 0 encroachment into either my property or the neighboring lot. He said his measurements matched his original survey within 1/10 of an inch. I paid him and asked him to email me a digital copy of the report. He said he would send it by end of day. I was walking back to my front door when I saw Donna's car pull up again. She got out holding the clipboard and the spray bottle. She walked straight to the fence line and started taking more photos. I asked her what she was doing, and she said she was documenting my continued violation. I told her I had a new survey report that confirmed the fence was legal, and I was emailing it to Greg and the board. She said the board did not accept third-party surveys without prior approval. I asked her what that meant, and she said any survey used for compliance purposes had to be conducted by an HOA-approved vendor. I told her the county accepted my surveyor, and that should be enough. She said the county and the HOA were separate jurisdictions. I asked her to leave my property, and she said the fence line was common area, and she had every right to be there. I told her the survey confirmed the line was the boundary of my lot, and she was standing on my side. She ignored me and kept taking photos. I pulled out my phone and started recording again. I asked her to state for the record why she was on my property without permission. She turned and looked directly at the camera. This conversation is not a debate. "It is a directive," she said. "You are in violation, and I am documenting it. If you interfere with my duties, I will add obstruction to your violation list." Then she walked back to her car and left. I went inside and called Greg again. This time, he picked up. I told him about Donna's visit and her claim that the board had overruled him. He sighed and said he had spoken to the board president and been told that the compliance decision was under review pending further documentation. I asked him what further documentation they needed, and he said they wanted a certified survey signed by an HOA-approved surveyor. I told him I had just paid for a second survey, and it confirmed the same results. He said he understood, but the board had specific vendor requirements. I asked him for the list of approved surveyors, and he said he would email it to me. I got the email an hour later. The list had 3 surveyors on it. I called the first one, and he said he was booked for the next 2 months. I called the second one, and got a voicemail. I called the third one, and he answered. I explained the situation, and he said he could come out next week, but his rate was $800 for a property line verification. I told him that was more than double what I had already paid, and he said HOA compliance surveys required extra documentation and liability coverage. I booked him for Tuesday morning. That night I got another notice taped to my door. This one said my fence posts were still in violation, and the $500 per day fines were accruing starting from the original stop work date. It listed a total of $1,500 owed so far. It also said that if I did not pay by Friday, the HOA would place a lien on my property. I took a photo of the notice and emailed it to Greg with a subject line that said urgent lien threat. He replied an hour later and said he would contact the board treasurer to clarify the fine status. On Friday morning, I drove to the hardware store to buy more materials for the fence. I was in the parking lot loading 2x4s into my truck when Donna pulled up next to me. She got out and started filming me with her phone. She said she was documenting my continued violation and my refusal to comply with the stop work notice. I told her the stop work notice had been withdrawn by Greg, and I had the email to prove it. She said Greg did not have final authority, and the board decision superseded his recommendation. I asked her to stop filming me, and she said she was within her rights to document violations in public spaces. If you are enjoying this HOA nightmare, smash that like button and subscribe so you do not miss what happens when Donna finally gets what is coming to her. A woman loading groceries into her car 2 spaces over stopped and stared. A man pushing a cart slowed down to watch. I told Donna I was leaving, and she followed me to the driver's side door still filming. She said she was going to submit the footage to the board as evidence of my ongoing defiance. I got in my truck and closed the door. She stood outside the window filming until I started the engine and backed out. She had to step aside to avoid getting hit by my mirror. As I drove away, I saw her in my rear view getting into her car. On Tuesday, the HOA-approved surveyor showed up. He spent 2 hours measuring and documenting everything. When he finished, he handed me a printed report and said the fence posts were exactly on the property line and compliant with all county and HOA setback rules. He also noted that the original survey I had used was accurate and properly conducted. He said he saw no reason for the HOA to dispute the installation. I asked him to email the report to Greg and copy me. He said he would. That afternoon, Greg called me. He said he had received the approved survey, and it confirmed my fence was compliant. He said he was instructing the board to withdraw all fines and cancel the emergency hearing. I asked him if that meant I could finish the fence installation, and he said yes. I thanked him and hung up. Then I called my contractor and told him he could come back tomorrow. He said he would be there at 9 a.m. Wednesday morning, my contractor showed up with his crew. They started setting the remaining posts and attaching the fence panels. By noon, the fence was half done. I was inside getting water when I heard shouting outside. I went to the window and saw Donna standing in my yard yelling at my contractor. She was holding the clipboard and pointing at the fence. I went outside and asked what was happening. She said the contractor was trespassing on HOA common area and she was ordering him to leave. My contractor looked at me and said he was not dealing with this again. He told his crew to pack up. I told him to wait, and I pulled out my phone. I called Greg on speaker and explained that Donna was on my property trying to stop the work again. Greg sighed and asked to speak to Donna. I held the phone toward her, and she refused to take it. She said she did not answer to regional managers, and only the board had authority over enforcement actions. Greg said loudly enough for everyone to hear that he had sent the board an email this morning, confirming the fence was compliant and all fines were canceled. Donna said the email was not binding until the board voted to accept it. Greg said that was not how compliance decisions worked, and if she interfered with the installation again, he would recommend the board remove her from the compliance committee. Donna stared at the phone for a long moment and then turned and walked back to her car. She slammed the door hard enough that I heard the frame rattle. My contractor asked me if it was safe to keep working. I told him Greg had just confirmed everything was clear and we should finish before anything else happened. He nodded and his crew went back to work. By 3 p.m. the fence was complete. I walked the line and checked every post and panel. Everything was level and solid. I took photos of the finished fence and emailed them to Greg with a thank you note. That night I got a call from an unknown number. I answered and a man said he was calling from Prestige Towing and he had been contracted by the Whispering Pines HOA to remove an abandoned vehicle from the common area. I told him I did not have any abandoned vehicles. He said the work order listed my address and described a red pickup truck parked in violation of the fire lane. I told him my truck was parked in my own driveway and it was not blocking anything. He said he was just following the work order and if I had a problem, I should contact the HOA. I asked him not to tow my truck and he said he would verify the location before proceeding. He hung up. I went outside and checked my truck. It was exactly where I had parked it, fully inside my driveway apron and at least 10 feet from the curb. There was no fire lane anywhere near my property. I took photos of the truck and the driveway and emailed them to Greg with a subject line that said urgent, false tow order. I also called the towing company back and left a message explaining that the work order was fraudulent and if they towed my truck I would file a police report and sue for damages. I did not hear back from them that night. The next morning, I found a new notice taped to my door. This one said I had failed to restore the landscaping disturbed by the fence installation, and I was being fined $200 for failure to maintain common area aesthetics. It listed a deadline of 72 hours to reseed and mulch the affected area. I took a photo of the notice and emailed it to Greg. He replied within an hour and said the HOA did not have jurisdiction over landscaping on private property, and the fine was invalid. He said he would contact Donna and instruct her to stop issuing unauthorized notices. I decided I was done waiting for Donna to follow instructions. I called an attorney who specialized in HOA disputes. Her name was Sarah Chen, and she had good reviews online. I explained everything that had happened and sent her copies of all my documentation. She reviewed it over the weekend and called me Monday morning. She said I had a strong case for harassment and improper enforcement. She said the HOA had violated multiple procedural rules, and I could file a complaint with the state regulatory office, as well as a civil suit for damages. She said her retainer was $1,500, and she estimated the case would take 3 to 6 months. I told her I wanted to move forward. She said she would draft a demand letter to the HOA and send it by the end of the week. On Wednesday, I got an email from the HOA management company scheduling the emergency hearing for that evening at 7 p.m. The email said the hearing was mandatory, and failure to attend would result in a default judgment against me. I forwarded the email to Sarah, and she said she would attend with me. We met at the community center at 6:45. The hearing room was a small conference room with a folding table and about 15 chairs. Donna was already there, sitting at the head of the table with the clipboard in front of her. 2 other board members were sitting next to her. One was an older man in a polo shirt, and the other was a woman in her 50s wearing a blazer. Sarah and I sat across from them. Donna started the hearing by reading a prepared statement. She said I had violated multiple sections of the HOA covenant by installing a fence without proper approval, ignoring stop work orders, and failing to remediate landscaping damage. She said the board had determined that my actions constituted willful defiance of HOA authority and warranted escalated enforcement measures. She recommended a total fine of $5,000 plus immediate removal of the fence at my expense. The other 2 board members nodded along as she spoke. When she finished, she looked at me and said I could respond if I had anything to add. Sarah stood up and introduced herself. She said she was representing me, and she had prepared a written response to the allegations. She handed each board member a stapled packet of documents. The packet included the county permit, both surveys, Greg's emails, the photos I had taken, and a timeline of every interaction with Donna. Sarah explained that the fence was fully compliant with all county and HOA rules, and that every fine and notice issued by Donna had been improper. She pointed out that Greg had confirmed the fence was compliant and had instructed the board to withdraw the fines. She also noted that Donna had issued multiple unauthorized notices and had engaged in harassment by filming me in public and sending a fraudulent tow order. Donna interrupted and said that Greg's opinion was advisory only and the board had final authority. Sarah said that was incorrect and that the HOA management company had delegated compliance decisions to regional managers under the terms of the management contract. She pulled out a copy of the contract and read the relevant section out loud. The two other board members looked at each other. The older man asked Donna if she had reviewed the management contract before issuing the fines. Donna said she did not need to review the contract because she knew the bylaws gave the board enforcement authority. Sarah said the bylaws and the management contract had to be read together, and the contract clearly gave Greg final say on compliance interpretations. Donna's face was getting red. She said this was a waste of time, and the board had already made its decision. Sarah said if the board proceeded with the fines and the fence removal order, I would file a formal complaint with the state HOA regulatory office and a civil lawsuit for harassment, improper enforcement, and violation of procedural due process. She said the lawsuit would include claims for damages, attorney fees, and a request for injunctive relief preventing the HOA from taking any further action against me. She also said she would subpoena all of Donna's communications, including her emails, texts, and phone records, to establish a pattern of retaliation. The older board member held up his hand. He said he thought the board should table the vote and ask Greg to attend the next meeting to clarify the management contract provisions. The woman in the blazer agreed. Donna looked at both of them and said they were undermining her authority. The older man said they were following proper procedure. Donna stood up and said she was calling for a formal vote right now. The older man said the motion was out of order because they had not finished hearing the evidence. Donna said she did not care, and she wanted the vote on record. That was when I played my trump card. I pulled out my phone and opened the video file I had saved from my doorbell camera. I turned the volume up and hit play. The video showed Donna approaching my front door 2 weeks ago, late at night, holding a printed notice and a roll of tape. She looked around to make sure no one was watching, then taped the notice to my door. But before she walked away, she pulled out her phone and took a photo of the notice on my door. Then she turned and looked directly at the camera and smiled. The timestamp on the video was 11:42 p.m., which was after the county noise ordinance curfew and well outside normal HOA business hours. The video also captured her saying to herself, loud enough for the microphone to pick up, "Let us see how he likes getting ambushed for once." I paused the video and looked at Donna. I said I had more footage showing her taping notices to my door at unusual hours, filming me without consent, and trespassing on my property multiple times. I also had audio recordings of her phone calls where she threatened fines and liens without following proper notice procedures. I said I was prepared to submit all of it to the state regulatory office as evidence of harassment and abuse of authority. Sarah added that the video clearly showed Donna acting outside the scope of her HOA duties and engaging in personal retaliation. Donna tried to speak, but her voice came out shaky. She said the video was taken out of context and she was just doing her job. Sarah said the timestamp, and Donna's own words proved otherwise. The older board member asked Donna if she had been issuing notices without board approval. Donna said she had full authority as compliance chair. The woman in the blazer said that was not true, and all enforcement actions required a majority board vote. She asked Donna how many notices she had issued without a vote. Donna did not answer. The older man said he was moving to suspend all fines and enforcement actions pending a full review of Donna's compliance activities. The woman in the blazer seconded the motion. Donna said the motion was out of order, and she was calling for a point of procedure. The older man said there was no point of procedure, and the motion was valid. He called for a vote. He and the woman in the blazer voted yes. Donna abstained. The motion passed. Sarah said she also wanted the board to formally adopt a resolution requiring all enforcement notices to include specific rule citations, photographic evidence, and a clear appeals process. She said the resolution should also establish an enforcement checklist that compliance officers must follow before issuing fines. The older man said he thought that was a reasonable request and he would draft a proposal for the next board meeting. Donna said the board was overreaching and trying to strip her of her enforcement powers. The woman in the blazer said they were just establishing accountability. Then Sarah dropped the second part of the trump card. She said her research had uncovered something interesting in the HOA meeting minutes from 4 years ago. She pulled out a printed copy of the minutes and handed it to the board members. The minutes showed that the board had voted to settle a property line dispute between two homeowners by officially recognizing the county survey as the definitive boundary marker. The resolution explicitly stated that HOA enforcement actions must defer to county-approved surveys when determining setback compliance. Sarah said the resolution had never been repealed, which meant Donna's entire enforcement action against me was invalid from the start because my county survey clearly showed the fence was compliant. Donna's face went pale. She said she had never seen those minutes, and they must have been filed incorrectly. The older man flipped through the document and said it was signed by the board president at the time and properly recorded in the official minutes binder. He asked Donna if she had reviewed the full minutes archive before issuing the stop work notice. Donna did not answer. The woman in the blazer said this was a serious procedural failure and the board needed to investigate how it happened. Sarah said she believed Donna had access to the minutes and had deliberately ignored them in order to pursue a personal vendetta. She said the video evidence, the unauthorized notices, and the pattern of harassment all supported that conclusion. She said if the board did not take corrective action, she would include the minutes in her complaint to the state regulatory office as evidence of intentional misconduct. The older man said he appreciated Sarah bringing the issue to their attention, and he would recommend the board vote to remove Donna from the compliance committee at the next meeting. Donna stood up and said she was not going to sit there and be accused of misconduct by an outsider. She grabbed her clipboard and walked out. The door slammed behind her. The older man looked at me and apologized. He said the board would issue a formal letter retracting all fines and confirming that my fence was compliant. He said they would also refund any fees I had paid related to the dispute. Sarah thanked him and said she would wait to receive the letter before deciding whether to proceed with the state complaint. The meeting ended about 10 minutes later. A week later, I received a certified letter from the HOA. The letter confirmed that all fines had been canceled and that the board had voted to adopt an enforcement checklist that limited the authority of compliance officers. The checklist required all notices to include specific rule citations, photographic evidence with timestamps, and a mandatory review by the regional manager before fines could be assessed. The letter also said the board had voted to remove Donna from the compliance committee, pending an investigation into her enforcement practices. 2 weeks after that, I received a second letter. This one was from Donna, written on plain paper with no HOA letterhead. The letter said she was formally retracting her claim that my fence violated HOA rules. She said she had reviewed the county survey and the archived board minutes and determined that her enforcement action had been based on incomplete information. She apologized for any inconvenience and said she hoped we could move forward as neighbors. The letter was signed and dated. I made 3 copies and filed them with the rest of my documentation. The following month, the HOA hired an independent auditor to review the compliance files from the past 2 years. The audit found that Donna had issued over 40 notices without proper board approval, and that at least 15 of those notices had resulted in improper late fees being charged to homeowners. The auditor recommended that the HOA refund all improper fees and implement a new oversight process for enforcement actions. The board voted to accept the recommendations and issued refund checks to every homeowner who had been improperly charged. My refund was $800, which covered the extra surveyor fees and part of my attorney retainer. At the next board meeting, which I attended, the board voted to adopt the enforcement checklist as a permanent policy. They also voted to create a new compliance appeals committee made up of 3 homeowners who were not board members. The committee would review any disputed enforcement actions and make binding recommendations to the board. Donna did not attend the meeting. I heard from a neighbor that she had resigned from the social committee and was planning to sell her house and move out of the neighborhood. I finished the fence that spring. It looks good, and it has held up through 2 storm seasons without any issues. My contractor did a solid job, and I recommended him to 3 other neighbors who wanted fencing work done. Greg called me a few months later to say the board had received a commendation from the state regulatory office for implementing the new enforcement procedures. He said the state had used Whispering Pines as a case study in how HOAs should handle compliance disputes. I thanked him for his help and told him I appreciated him standing up to Donna when it mattered. I still see Donna occasionally when I am out walking. She does not make eye contact and she crosses the street if she sees me coming. I do not go out of my way to talk to her, but I also do not avoid her. The fence is still there, right on the property line, exactly where it belongs. I will see you in the next story.